Call to order the Children and Family Law Committee of the House. First up is House Bill 547. The chair calls Representative Testerman to present his bill. At this time, the chair can exercise the prerogative of putting the bill into play. We will now be hearing on House Bill 547. I have one pink card that has made it this far with, looks like some more coming. And just to let everybody know, these bills are scheduled at 45-minute intervals. So if we have a flurry or plethora of pink cards, we will have to hold you to the 2 minutes you're asking for, and maybe even give you an extra minute. So Bill 547 is now in play, and the chair recognizes Erin, is it Jacina from New Hampshire Legal Assistance to speak against the bill, and you asked for 2 minutes, and I'll give you 3. Yeah. Thank you. There's one rule.
Okay.
Oh, I'm not either, and I learned.
All right, I will start over. Good morning, Mr. Chair and members of the committee. My name is Erin Jacina, and I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance. We represent low-income victims and survivors of domestic violence, sexual assault, and stalking in their high lethality protective order cases and family law cases, including divorce and parenting. I am here today to testify in opposition of House Bill 547. First, I just want to thank and appreciate the sponsor for his efforts to make things better and safer for victims of domestic violence and their children in the family court system. There are pieces of this bill that I think are worth considering, but generally speaking, this bill is a complete overhaul of the parental rights and responsibility statute that we currently have, which, if this bill is passed, would dramatically change the landscape of parental rights and responsibilities in our state. And those could have some negative consequences for victims. And practically speaking, there are some things in this bill which are not possible to implement. And I'm happy to go through the bill line by line, but I don't think even within the 3 minutes that the committee has time to hear of that. But I am happy to answer any questions that you may have. Also happy to be a resource on the family court system at another time if that's helpful to the committee. But quickly, I would like to go over some of the major issues that we found were problematic with this bill. First, this bill requires a parent who is found to be abusive to have supervised visitation with their children at a supervised visitation center using a metal detector. I am fully supportive of the use of supervised visitation centers. Sadly, we only have one left in our state, which is in Dover, that uses a metal detector and follows best practices. So practically speaking, this would not be a possibility for every parent who has been found to abuse their partner or their child to go to the one center in Dover. Secondly, it requires the therapist to essentially clear an abusive parent for visitation. No therapist will, in my experience, or should ever clear somebody for or state whether or not somebody has the potential to abuse in the future. Lastly, this bill requires a restraining order to be entered in all cases with no exceptions for co-parenting contact. Again, I'm supportive of the use of marital and parenting restraining orders, but this would effectively limit the ability of parents to co-parent. So it says in all cases, there shall be a restraining order entered. So that means if the restraining order is in place and there's no provision for contact between the parents regarding the children, that let's say Johnny wants to go to a play date at Chuck E. Cheese, dad can't contact mom to say, I will pick up Johnny at Chuck E. Cheese at 4 o'clock. It would eliminate any contact between the parties, which again would make co-parenting extremely difficult. Again, I'm happy to answer any questions. These are the three major issues that we saw with the bill. There are other issues. So at this point, we are requesting the committee to vote in expedient to legislate, or at the very least, push to a study committee to determine whether or not changes to our parental rights and responsibilities statute need to be made, and if so, what those changes might be. Thank you.
Thank you for your testimony. Bill Writing 101. I see no co-sponsors, so I do not see collaborative effort, at least in the list of sponsors. Did the sponsor of the bill reach out to you for your input along the way?
No.
I'm going to ask that of everybody who's going to come up and speak. To your knowledge, was there access of what other states do?
I don't know any of the background related to this bill.
We have 50 states, 50 experiments in democracy. We're not the only ones who face this problem. So this is for anybody who cares to listen. Collaborative effort in terms of asking me to ask the committee researcher what do other states do is always important. Any questions of Ms. Jacina? Yes, welcome back.
Thank
Did
you.
you work last night?
I did not. I worked day shift yesterday.
You're all sparkly and fresh.
That's correct. Thank you, Mr. Chairman. I'm just wondering how they would prove that domestic violence happened. That's one of the issues that I have with this bill, that you have to prove, and domestic violence can be very difficult to prove.
Agreed. There are some provisions to show that abuse occurred under 173B or 169C. I can't say whether it requires that somebody get a domestic violence protective order. And as we know, even if somebody doesn't get a domestic violence protective order, that doesn't mean that they are not a victim of domestic violence. Sometimes it is not always the safest option for somebody to seek a protective order under 173B or 633A, which is our stalking statute. Sometimes in family court, people are able to testify to abuse that has occurred, whether that be verbal, emotional, physical abuse, and the court is able to make a finding of abuse, and they will use that finding to determine decision-making and residential responsibility. So it's unclear, to answer your question more directly, it is unclear in this bill what would be required in order to make those findings, which would then lead to the supervised visitation and then a therapist determining somebody is cleared for future visitation unsupervised.
Representative McMahon.
Yes. Thank you, Mr. Chairman. Is it Attorney Justina?
No, I'm a paralegal.
Then paralegal, Ms. Justina. Get it straight.
Although I am able to represent clients in court now under the new rule that you all and law that you came up with last session. So thank you very much.
You're welcome.
And that's not under appeal, right?
It is not.
Okay, good.
I represented my first client last Thursday.
Congratulations.
Thank you.
A question relative to the statement that's written multiple times here, rebuttable presumption. My personal understanding on reading legalese is that would give the authority having jurisdiction, the judge, the ability to make a decision without having testimony from one or both parties. Is that correct, or what's your guidance on that?
No, I would believe that they would have testimony from both sides in a full evidentiary hearing. Both sides will be able to provide their testimony, and then the judge would make a decision one way or the other. It doesn't mean that they can't provide evidence or testimony. It's just that would be essentially the default, and then if there was evidence to the contrary and the judge made findings, would be able to make a different determination.
Okay, thank you.
Representative Bickford.
Thank you, Mr. Chairman. I'm sorry, I missed where exactly your 3 points are in the bill. Could you tell me where those are? You need a
Happy
bill?
to. I do. I did not bring that up. Thank you so much. Okay, so to the first point, requiring the parents to have supervised visitation, line 21, page 1, section 5, if after a full custodial hearing. Oh, sure. Is a asterisk fine? If I just, okay. The court orders supervised visitation, it shall order that such visitation shall take place only at a visitation center using a metal detection device. It is also on page 2, section, lines 31 through 37. My second point, requiring a therapist to essentially clear, and clear is my word, is on page 1, lines 13 through 19. I think it was in another section as well. I'm just quickly looking. And then the piece about the restraining order is on page 4, lines 26 through 36, and then it goes on to page 5. And there are some repetitive sections in the bill as well, so this may be repeated in other places in the bill. Thank you.
Any other questions? Seeing none, thank you for your testimony.
Thank you very much. I appreciate your time.
And by the way, I took the practice LSAT section on children and family law and aced it, so maybe we can go to law school at night together. You're welcome. Chair recognizes Randall Collier to come up and speak. Please, sir, no, you have now 3 minutes. We're into the 3-minute rule here, and I enforce it. So if you have a story to tell, be brief.
Thank you, committee and the chair. My name is Randall Collier. I have a lot of problems with this bill. Primarily, I have a lawsuit pending because of these statutes, and a lot of them don't make any sense. Whereas it seems that the family court judge, it's an equity court, and the only way to actually take your rights away is to be in a criminal court, in a criminal proceeding with jury by your peers, and 3 elements to a crime. And to the ladies speaking about the evidence of being a victim of domestic violence, you're right. You know, it's hard to tell. However, you know, when testimony contradicts evidence and a judge goes with the, you know, testimony, it's hard for someone to rebut being found under a criminal statute, but not actually in a criminal court. So there's obviously a conflict of interest using criminal statutes, not in a criminal court. Thank you.
Next time you come back, I owe you 1 minute and 55 seconds extra. Thank you, sir. That very succinct and much appreciated. And Dana Albrecht, Mr. Albrecht.
Thank you, Mr. Chair. Dana Albrecht, Nashua, New Hampshire. I have some exhibits. You can look at them later just in support. I'm strongly opposed to this bill as written. It relies on RSA 173B, which at this time I believe is an unmitigated disaster in practice as actually implemented right now. It's an unholy amalgamation of civil and criminal law where the defendant is subject to all of the penalties of criminal law and none of the protections traditionally afforded a criminal defendant. In particular, no right to an attorney. RSA 173B right now is essentially used in two capacities. In practice, one is to issue legitimate orders of protection that are badly needed, and we hope the victims get those. Sometimes they don't. And the other is that it is often used by plaintiffs acting in extremely poor faith to game the system. To that point of gaming the system, I have just two examples for you here. Exhibit A is a pending court case up at the New Hampshire Supreme Court, CBVAK docket 2022-0463. And from that, we have a letter from the defendant in jail. It may not go down in history like Gideon v. Wainwright or Martin Luther King's letter, but it's definitely worth reading. I'd encourage you to do that. He's been there since December 20th, and his position is all he's done wrong is send a non-parenting text message about parenting to their child's mother, and he's still in jail for that.
And you have 1 minute left.
Exhibit B, we have a case where somebody wants to game the system. We have a registered sex offender here who went in as the plaintiff and basically got Judge Lemire to give him an order of protection. And not sure how that happened. Mistakes were made. But she's given some great testimony before this committee before. So also gaming the system here. So I would, in conclusion, just suggest that we would really need a complete overhaul of 173B before even going anywhere with a bill of this nature. Thank you very much.
so much. Any questions, Mr. Albrecht? Just want to tell you, my mind usually shuts down around minute 4, and so everybody's been very good. I've listened to everything everybody said so far. Thank you.
Thank you.
Chair recognizes Vivian Gerard. She asked for 2 minutes. I'm going to give you 3.
Thank you, Chair and members of the committee. I just wanted to speak today quickly because a lot of the things that you guys are discussing in this bill, I really disagree with, because just a quick story here. My ex tried to put a false police report on me so I could lose my children. He's still trying to fight sole custody with my children. And he will try to find any way possible to try to put a domestic violence, not only on me, but he's constantly trying to go around the system to get sole responsibility of my children, and I have primary residential. So passing this bill, I just wanted to say that it really should be reconsidered, and looking at some of the verbiage in here, I just really disagree with. That's all.
Thank you so much. Any questions? Seeing none, the chair now recognizes Richard Head. That's attorney Richard Head, right?
Sorry?
Attorney Head?
It is.
Yes, well,
although Richard,
graduate school in England, I stand on ceremony. Okay.
Richard is fine too, though. Thank you. Good morning, Mr. Chairman, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. I do want to just point out some aspects of this bill that are problematic in terms of how they can be implemented. Some of it's definitional. I won't go into a lot of the details. The bill uses the term family violence. That's not a specifically defined term. So if we take the definition of family and the definition of violence within sort of the domestic violence context, it's a fairly broad term, I think, although not specifically defined. So it would be subject to some level of interpretation as to what is intended by family violence, but that may have some fairly broad scope. And then the implications as it flows through this bill, as you've already heard, and I won't repeat, become very broad. We agree with the point of Aaron Justina regarding the visitation centers. It would become sort of a functional ban based on the fact that there's only one supervision center that meets the criteria in the state. The other aspect of the bill is it creates prohibitions based on family violence, but it doesn't give a time frame. So it doesn't say when the family violence may have occurred, what circumstances may have related to it, so there's no sort of consideration in the bill for discretion with the court to evaluate all the facts and circumstances and to establish an order that meets the needs of an abused victim, the children, and the parents. So the phrasing of the bill is frequently in the context of shall. It creates an absolute mandate without exceptions. As an example of that, on page 2, beginning at line 31, talking about in determining parental rights and responsibilities, creates a presumption that the presence of child abuse under 169C or domestic violence creates a rebuttable presumption. And it goes on, and again, doesn't talk about time frame or any attenuating circumstances or sort of a what is the nature of the balance. Where it becomes somewhat more problematic is in the going from page 2, line 36, if there are 2 instances of continued abuse in or around the exchange or the supervised visitation of the child, under the statutes, the court shall suspend visitation altogether. And again, it's a mandate without sort of an evaluation of what's going on, and it's not clear exactly as to how that would be presented to the court the way it's phrased. So there is, because of the absolute mandate stated in here, there is a risk, as you heard from some of the other testimony, about the statute becoming weaponized, and the allegations. There may be an encouragement to create an allegation because the statute, as written, creates an absolute requirement of shall suspend, and that then sort of becomes a process within a case. My last point is 2 more points. I apologize. Page 2, beginning at line 1, inserts a new introduction to paragraph Roman 1. It is essentially the exact same thing with a statutory change as paragraph 3, which would be deleted. Once you start moving paragraphs around within a statute, you then have a sort of a carry along of every time a section is referenced, that needs to follow along. If we have a form that references it, that needs to sort of get changed. And it becomes sort of an unnecessary complication when all you're doing is changing a word within the section. My last point is more or less an educational point. I've made this point a lot last session. I've had to do it fewer times this session. Is the effective date. And it says 60 days after passage. There's a statute which I handed out, and you may hear me reference it relative to other bills. RSA 14:9-A is a statute that governs effective dates. It has a very specific requirement relative to anything that affects judicial processes, essentially. And it says that they shall become effective on January 1, on the January 1 following passage. And that's under RSA 14:9-A, paragraph Roman 2, small a. So any of these bills that impact the judicial branch that have an effective date other than January 1, we just ask that those get changed. With that, I would conclude my testimony. I'd be happy to answer any questions.
Any questions for Attorney Head? I have one. Did the prime sponsor, only sponsor of the bill, consult you in any way while crafting this bill?
Thank you for the question. No, we did not hear from the prime sponsor.
Thank you. Anyone else? Thank you for your testimony.
Thank you.
And the chair now calls Pamela Keilig. I was going to say pardon the French, but it's German.
No, that was perfect. Not
3
many-
months in Germany. Okay.
Yeah, no, not many people get that on the first try, so thank you. Good morning, Mr. Chair and members of the committee. My name is Pamela Keilig, and I am the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. The coalition, as some of you might know, is the umbrella organization for 12 community-based crisis centers who provide free and confidential services to nearly 15,000 survivors of sexual and domestic violence annually. I'm here to speak, and I'll keep it brief because I echo the concerns shared by Attorney Head and Aaron Jacina. We oppose the bill as written, and because of the significant changes it would make to the statute. We really appreciate the sponsors' efforts to recognize the importance of protecting victims and their children when determining parental rights and responsibilities in domestic violence cases. However, while there are some positive things that could come from this legislation, we are really concerned about some significant unintended consequences that could come, that could be at the detriment of victims and their children. And we find it really important to strike the right balance in the law. So we would just ask the committee to consider, at the very least, allowing us to further study what changes could be made, if there are any, to ensure that the appropriate protections are in place. But at this time, we find the bill inexpedient to legislate and would like you to consider that as well.
Will you take questions?
Absolutely.
Thank you. Any questions? Did the sponsor consult with you?
No.
Okay, thank you. And that concludes the hearing, the testimony. Thank you so much. With the approval of ranking member, I close the hearing on Bill 547 and now open the executive session on the bill. While we have the last handout coming around. Okay, let's. Yeah. Okay, folks, before I'm ready to entertain a motion, just anybody's thoughts on the bill before us? Anybody want to hand up and share something? I think Representative Bickford does.
Okay.
He's getting ready to put his hand
The
up.
language that they're working with here, this language that we put together in 2005 from the Family Law Task Force, and they're looking to, it's being looked at to amend that. And I have to agree, I'm not favorable to it after reading it. You may be going too far, and yeah, it sure will weaponize things. That's my estimation. I didn't hear anything about the guardian ad litem list. I was sort of interested in how that might play out. I do wish we could exec at a different time because people write in up till noontime to send us information on these things, and we're not getting the opportunity to look at those things. That's my little protest.
Okay. Anyone else? Any thoughts about the bill before us. I hear from other committee chairs that their members talk too much.
Maybe it's because we listen better.
Oh, because you listen better. Yeah. Well, my thoughts, there was no consultation with either the executive department or judicial department relative to the bill. There were no co-sponsors, so it hasn't seemingly been hashed out with other legislators willing to put their name on it. There's no documentation of what other states do. Sponsor even is not present. Besides being noticed in the calendar, I sent out an email ahead of the calendar to people letting them know when their bill will be heard. I think it's not just one, but maybe two bridges too far. There's good stuff in it, and even everyone who spoke here thought so. This is the kind of situation where I'm very tempted to say, let's sit on this for a bit and rewrite it, except this is an early bill and it's got to get out the door fairly quickly. I don't think there's time to rewrite an amendment big enough to consult with everybody and get the research and do the things that would make us have a good possible amendment. And if it's big enough, it might be arguably in part non-germane, which means the speaker has to rule on it and so on. So we have a clock issue as well. I would entertain a motion. I think you know where I'm going. I can make the motion. I'd rather not. Would somebody care to make a motion?
Can we make a motion to ITL?
Representative Levesque, I saw your hand. You're making a pointer motion, right? Okay. Yes.
I'm just going to echo what Representative Perez said. I was going to make a motion to ITL.
All right. We have a motion from Representative Moulton to ITL. Do I hear a second? And the second was Representative Gregg.
Oh, excuse me, Chairman. I was the one who made the motion to ITL.
You did?
Yes. Yeah, I was
Oh.
like, I had my hand and I said, can we ITL?
I'm sorry.
That's okay. Don't
I
worry
don't
about
hear Spanish quite as well,
it.
but I'm working on it. As you know, I can roll my R's.
That's okay.
Okay, so that was Representative Perez. I misread where your finger was pointing. I apologize for that. Or not.
Okay. That's fine.
So, Mr. Chairman, over here, has the policy changed about starting with a positive?
Yes.
Good.
And so therefore you have been rehabilitated from doing it the first time. Yeah, they did change that.
Okay.
So Representative Perez moves, and who seconded it? Representative Moulton, and you're in the on-deck circle for another bill, okay? Good. And the rule, as you know, is you get to write the committee report, making a motion, and if it needs to be defended from the floor, you get first dibs on that, which doesn't mean you have to do it, but it means if you want to, go for it. I have to turn that information in. Any further discussion on this? When the clerk is ready, please call the roll. The motion on House Bill 547 is ITL, moved by Representative Perez and seconded by Representative Moulton.
Chairman Pierce.
Not present. Chairman Pearson.
I apologize.
That's okay. I've been calling you Patigno, and I don't think that's correct. It's Patigno? We'll go out after. The motion is ITL. Yes.
Chairman Pearson to ITL, yes. Representative Long.
Yes.
Representative Disimone.
Yes.
Representative Bickford.
Yes.
Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic is not present. Representative Seidel.
Yes.
Representative Grossman is not present. Representative Levesque.
Yes.
Representative Petrino votes yes. Representative Perez.
Yes.
Representative Gregg.
Yes.
Representative Moulton.
Yes.
Representative Raymond.
Yes.
The vote is 14-0 with 2 not present.
Any objection to going on consent? Seeing, hearing none, thank you very much. This concludes the exec session on House Bill 547. At 10:15, we will take up House Bill 600.
What do they call you?
Pierce. actually leave them at the end of the table and he will bring them forward. Representative Bickford will. Thank you.
We know.
Okay. Now open the hearing on House Bill 600, an act relative to temporary orders for parental rights and responsibilities. The chair recognizes the prime sponsor, Representative Testerman. Seeing that the prime sponsor is not here, the chair now recognizes Attorney Richard Head from the judicial branch to speak to this bill.
Morning, Mr. Chairman, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. A couple sort of construction comments relative to this.
Would the attorney please hold for a second? I need a
course.
state rep to introduce the bill. You can stay right there. So would you like to do that?
I'll yield the chair for a second.
I'll introduce House Bill 600 relative to temporary orders for parental rights and responsibilities.
Thank you very much, Mr. Vice Chairman. And now, see, this is why I have people smarter than me. It's the only way.
It's good to have a team.
It is.
Thank you again, Mr. Chairman. Richard Head, Government Affairs Coordinator for the Judicial Branch. Just a couple comments about this bill. So page 1, line 5, it's a short bill. Says temporary hearing orders shall be held within 30 days. We don't know how you hold an order, so we're not quite sure what the intent of the sponsor was there. Relative to your question with the last bill, we did not receive any request for input from the sponsor. It relates to, again, and then going on 30 days after the filing, a petition that gets filed still has to be served. There has to be process. Frequently you see dates from return of service, for example, so that all the parties now have notice that that there's a proceeding and that a hearing is going to be scheduled. The timeframes are not necessarily, so this relates to temporary orders. And talks about after a filing of a petition concerning a minor child, the court, and then it says shall issue orders instead of a may, taking away that discretion from the court with such conditions and limitations. It's not consistent with some of the other provisions within RSA 461A, such as 461A:9, which talks about ex parte temporary orders, requires a hearing within 5 days. So that does fit. However, it's only if there is a specific request for a hearing. Ultimately, there may not be a request for a hearing. This bill would mandate a hearing where the parties do not actually necessarily want one or have not requested one. It's also inconsistent with 461-A:9, which talks about 30, actually not necessarily inconsistent, but that's an example of where we have 30 days from service. We do have concerns generally about bills, and there are a number of bills this session that impose mandatory deadlines on the court for hearings. We have one of our most valuable assets is our docket. We have a docket that every judge has. It cannot be longer than 7.5 hours while the court is open, and they get filled. And we're talking about circuit court. So we're talking about family division cases and district division cases. And they fill a docket. And there, as we add more and more mandatory hearings into our docket, that creates fewer openings for all of the cases that don't have a strict mandatory deadline. And there are a large number of statutory or constitutional provisions that set requirements. So that then ends up creating just significant operational limitations for court staff and the judges to implement or to put together a daily docket. We do have significant concerns about anytime we start putting in mandatory 30-day, 45-day deadlines, and without sort of exceptions. If the parties ask for more time, it's not allowed for in here. If the parties have some sort of have a mutual agreement, they don't need hearings. That's not accounted for hearing in this process. So there's just a lot of things that have ripple effects in the system that have not been contemplated in this bill. And we think that just in and of itself creates some significant operational problems from the court's perspective. With that, I would conclude my comments, but would be happy to take any questions.
Any questions for Attorney Head? Representative Raymond.
Thank you, Mr. Chairman, and thank you, Attorney Head, for taking my question, and to Mr. Chairman for noticing my lean. I'm trying to get around the corner here. My question is regarding situations where service is not happening. So where a party has filed in court and then they've attempted to serve the other party and it doesn't work. What typically happens then? And would this bill make any changes to that? Because as I was reading it, I was thinking that might be where this person was trying to go with the bill.
So I don't read it that it would make changes to the service aspect of so problematic service where a person has moved, we don't know where they are necessarily or whatever, maybe limiting service. It would be a request to the court for alternative service. So publication, something else, but there would be sort of a process that would go before the judge just asking for alternative service. And I apologize to take another point. Anytime the courts receive requests for temporary orders, they are evaluated in terms of, is there an emergency situation? Is there a circumstance where speed is appropriate? And that's one of the factors the court would take into account. So if there's a need for speed, the court will schedule stuff quickly. And if the need is there, in less than 30 days. So I'm not saying that these are not important orders, but the sort of strict deadlines without consideration of the consequence of the circumstances creates sort of an unnecessary burden. Anytime we're dealing with temporary orders, those tend to be sort of the higher priority types of requests within the system, but they don't all need necessarily to be heard within a strict deadline.
Any further questions? I'm just reading ahead in the 461 section here, and it looks like it expands on what you're saying, is if speed is necessary, speed is possible.
Speed is absolutely possible, and I should have just started with that. I have it in my mind, it's just implied, and I forget to vocalize things sometimes, but there is language already about exercising, appropriate speed, and it is no, the clerks do that when they receive these types of requests. So it's built into the system already. But the lack of discretion either by the parties or the court sort of creates unnecessary limitations and burdens.
I think you'll understand we face much the same thing in scheduling and moving bills through.
Absolutely. Absolutely.
Thank you so much.
Thank you.
And the chair recognizes Vivian Gerard. She says she wants to speak for 1 minute in opposition to the bill.
Thank you, Chair and members of the committee. I have to strongly agree with Richard Head on this one, because when you're throwing a 30-day limit in the court systems, as we all know, speed does not equal court. if a judge is supposed to be getting an order out in 30 days, we can't even get that out of them. So how are they going to come up with a 30-day window on a temporary hearing? And all those other cases, like myself, I've been in the court system for 9 years. So that just keeps bumping other cases like mine where you don't get an answer. And the only people that suffer is the family and the children. Thank you.
Any questions? Seeing none, thank you so much. And Mr. Randall Collier, welcome back. Representing yourself in opposition to the bill, needs 3 minutes to speak.
Thank you, committee and the chair, and let me speak in opposing this bill, 461A8. Just kind of curious, I agree with the other speakers regarding the timeframes. If anyone's ever been on the other side of this, waiting 30 days or even 45 days or any amount of time to be without your kid is detrimental to their well-being as well as the parent. Understanding it says the orders may be issued ex parte, I'm kind of confused how the due process and the evidence to defend if it's an ex parte and one party is not there to represent and to defend themselves. Seems unconstitutional to put that in there. I'll take any questions.
Is Attorney Head in the building? We could take a continuing education moment to, could we explain your question, his question about ex parte and some of those little nuances of law? And thank you for raising that point.
Thank you, Mr. Chairman. And I'll talk generally about ex parte requests. An ex parte request is typically filed with the court where circumstances may be so urgent that there's insufficient time to bring the other party into the court to provide them notice, opportunity to be heard, but the circumstances are such that on that day a party is looking for some sort of relief from the court, whether it be protection, whatever it may be. It may be relative to access to children, broad scope of potential issues that may appear before the court on a ex parte, meaning no notice to the other side. And the court would review that particular request. They may or may not ask him for more information if the pleading is insufficient, and an order would get issued. And if the order is to grant the motion for ex parte relief, the court also then would be scheduling a hearing, typically within 5 days, to allow for the party to get notice. It may be even shorter, and an opportunity to come in and provide their view of the facts and circumstances. And then the court would reevaluate its ex parte order. Now that's had an opportunity to hear from all the parties. It may or may not issue a new modified or withdraw the order, depending on the additional facts that it may learn.
Ex parte simply meaning by the part. One party is present, the other is not.
Exactly. I mean, it's just the filing party. The other party may not even know that there's a request filed at that point.
Good. Any further questions during our continuing education session, Vice Chairman Long?
Thank you, Mr. Chairman. I mean, we do get numbers on parenting petitions and all that. I'm wondering if is there a number of how many of these ex partes with no notice, and a qualification that it is 5 days and it's not 10 or 20?
It is 5 days.
It is.
So it depends on the statute. So if we're talking about under 461A, it's 5 days.
Okay, so just a number of how many of these
Under 461A,
happen where there's no notice.
I will check if it pops out of if we can extract
Okay, I
it, and I'll
appreciate
send an
that.
email to
That'd
the
be
committee.
great. Thank you.
Stipulating that the prime sponsor may have a point, and also stipulating that the difficulty is, as you had said, what is a possible third way to see what would we need to do to honor the speed that is requested in the bill and yet make it possible without inconveniencing others, as Mr. Rod pointed out? Is there a possible remedy down the road, in your opinion?
So I guess I'm unsure as to whether there's a problem in the first place. I don't know if, I'm not sure what the problem is we're trying to address in order to put language in that fixes it. Because I think as appropriate, we are scheduling hearings quickly. There, to the extent there are delays, it tends to be because the docket day, 7.5 hours for that judge, is just full, and we're trying to put it in. If it needs to be, we will. Some parties may view theirs as needing, and in fact, 40 days may be sufficient. Or nobody's requested anything, and we don't need to, and the parties have an agreement. We don't want to hold a hearing, fill up a docket time when all of the parties have filed a stipulation of agreement. So to your question, I don't know what the exact problem is we're trying to address in terms of scenarios that could then translate into policy language.
Thank you. And thank you for our continuing ed session.
Thank you.
And I think we may need a few more in the course of the day to fill up the time we're here, and make some notes and let's see what we can do. You got it. Chair recognizes Dana Albrecht. He asked for 1 minute. He is in support of the bill. Maybe this can answer part of our question.
How about I say, Dana Albrecht for the record, how about if I say I'm in strong support of the bill with appropriate language cleanup to address a lot of the concerns? My case has dragged on for 6.5 years. I currently have an appeal, docket 2022-0517, raising claims of unconstitutional delay going over 2.5 years without getting a hearing on a simple motion for enforcement. Most parents don't have the luxury of kind of doing that, though. So I think we really do need to get into statute some kind of language to implement reasonable timeframes to get parenting petitions done. In particular, I point out that all DV requests actually happen ex parte with no notice and have to be heard within 30 days. And if we're doing DV petitions, why can't we do something similar for parenting? And at the moment, that creates even a bigger problem because, as mentioned earlier, certain unsavory plaintiffs might wish to use the DV mechanism to kind of do an end run around all of this and get some of the things that this bill, I believe, is meant to have happen the right way, and they get to do that the wrong way. And that's about all I'll say. I'll take questions if there are any.
Seeing, hearing none, thank you so much. And I, just under the wire, another pink card.
Could you recognize me just briefly? Get rid of the ex parte language. Thank you.
Thank you. I was reading exactly this point. Come up and
Thank you, Mr. Chairman, and Erin Justina corrected me, and she's absolutely right. So what I testified to is it's 5 days for ex parte. It's 5 days if requested, 30 days if the request is not received. So my mistake, and I apologize for that.
that's 461A9 Roman 3 and following.
That's correct. I think that's right, but
Well, I had the book, so I have
I don't have it in front of me, so that's correct. I'll rely on that. But so I apologize for the error.
Thank you for the correction.
Thank you.
This closes the hearing on House Bill 600, and I now open the exec session with the agreement of the ranking member on House Bill 600. I'd like to have a little sense of the meeting discussion before I receive a motion. So I'd like to speak. Representative Moulton.
Thank you, Mr. Chairman. I do agree with the first person that spoke. I forget who, I forget what his name was, but regarding that there's other deadlines, like the person needs to be served, and you don't necessarily know what the parenting plan needs to say until the time has elapsed and you've kind of fleshed out some of the issues. You do need that time. So these short time frames, while they might provide some level of benefit, it might end up in incomplete temporary parenting orders, and that might end up elongating the process in the long run.
Thank you. Anyone else wish to speak on the committee? So,
Questions,
yes, Representative DeSimone.
portion of 461A3 that has been referenced in this, with this bill?
469-A:9, sub-Roman 3, if temporary orders are made ex parte, the party against whom the orders are issued may file a written request with the clerk of the court and request a hearing thereon. Such a hearing shall be held no later than 5 days after the request is received by the clerk.
Thank you, Mr. Chairman. May I make a statement?
You, on one condition, is that you turn on your microphone, please.
Thank you.
You're welcome.
Sometimes I use my mama voice and don't think I need one. Anyway, I think that 469A3 blah blah already answers to this. So, thank you.
Back for more, Representative Moulton.
Thank you, Mr. Chairman. So ex parte is that they, if you know, Rep. DeSimone, that ex parte you do, that it's just one side? Okay, thank you.
Mr. Chairman.
Representative Bickford.
Thank you, Mr. Chairman. These bills that we have today seem to be entering into the realm of the machinations of the court, of which I don't really know the details of how the court needs to file, et cetera, et cetera. And I would, before I could pass these, I would want to have at minimum a subcommittee to help me understand, like you need somebody from judiciary to augment or help understand the problem that we're trying to solve. So that,
One of the motions that we may consider is the motion to retain, which means we hold on to this. Individuals may meet, I may appoint a subcommittee, and in the fall, we come back and consider based on that group of people's work, I hope in consultation with the judiciary. So retain is a motion. We don't have to pass it. We don't have to kill it. We can keep it. So just for when it's time to make a motion, would that speak to what you just said?
I think so. It is also in term study. You want to retain, that would be a subcommittee or something?
It could be.
I've kind of forgotten the various ways.
Well, it kind of, yeah.
Yeah. Anyway, I'm stuck with that. I just don't know enough about the system to be able to make an intelligent decision on this.
I might suggest to those of you considering writing bills for next time, you do that work up front. There's a lot of prep work before you start to see the ground floor of a skyscraper. They go down several floors to build the foundations. That's the foundation of good bill writing, is to check with the people who know, to ask the questions that need to be asked, to have them give information we didn't know how to ask. But given that that may not have happened here, I don't know, we can keep it ourselves and do that work if we wish. Anyone else? Yes, Representative Vice Chairman Long.
Thank you, Mr. Chairman. With respect to retaining, I mean, it's difficult to know what the intent is when the sponsor's not giving you what the intent is. It may be a good intent. I don't know what it is. But we have to remember that if we retain this, this becomes our bill.
It is our bill now,
and
sir.
we do what we want with it. And you know, is that what we want to do as a committee? Start taking bills and sort of twisting and turning them as to where we think they ought to be going. So, you know, as the chairman mentioned, there is a due diligence process that gives us the information, and even if we were to retain it, I don't even know what the intent of the bill is. So where would I start? So that's that.
If I'm not mistaken, once the bill has been assigned to this committee, it is no longer the sponsor's bill. It is our bill. So we can do with it as we wish. We can change it as we wish. This is a platform for our going somewhere, and we really don't necessarily need to know what the sponsor's intent is. We can ask, we don't have to. We can take it and make it something should we choose to. And that's a little work group, and it reports back when we come back in September, October, and then we decide what to do, and on it goes on its merry way till next year. Any other questions? Any thoughts? Anybody wish to make? Let me ask you this before we do it, because it's easier to do it when we're not doing it officially. How does the idea of retain and work on it strike you? This is not an official vote, but it's a sense of the group. I don't see hands. Do I see hands for retaining? Okay. Do I see hands for passing the bill? Okay, you know what's left. The chair will entertain a motion.
Over here in the corner.
Okay, and I owe you a second. Yes, represented, I like to do it bipartisan, but well, that's okay. We're all friends. The motion is from Representative Raymond, and the motion is,
Regretfully, ITL. I just don't think it's going to
okay. No, you're in next. I owed her one from last time, remember? Do I have a second? I knew it.
I'll second it.
I know you will. Okay, and we'll remember you for next time. Okay, got it? Oh, you've done this before. Give the freshmen some fun, right? Any further discussion? The assistant clerk will call the roll on House Bill 600. The motion is ITL, moved by Representative Raymond, seconded by Representative Gregg. With the assistant clerk now please call the roll. If you want ITL, it's a yes or an aye. If you don't like ITL, it's a nay or a no.
Chairman Pearson,
Yes.
Vice Chairman Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball, yes. Representative Panic. Oh, sorry, absent. Representative Seidel,
Yes.
Representative Grossman. That's an absent too. Sorry, I can't see down there. Representative Levesque,
Yes.
Representative Patrickno,
Yes.
Representative Perez,
Yes.
Yes.
Representative Gregg,
Yes.
Representative Moulton,
Yes.
Representative Raymond.
Yes.
So that is going to be 14 yays, 2 are not here. So the ITL.
14-0. And any objections to consent? And before we leave today, if I may have the committee report, AKA the blurb, from Representative Raymond. This concludes the executive session on House Bill 600, and we will reconvene at 11 o'clock on House Bill 404.
Actually,
Who knows how to write a blurb?
we don't have a minority report.
I immediately regret my decision.
Yeah, consent.
Do I do it in Word or can I just send an email?
Yes, over here. for minority.
No, no, it's a majority.
They're just cheap,
because the
okay.
Majority is voted to ITL.
Last year, what I did to make it easier on Aaron was that I would
Right.
So many, but, I know that, Chairman likes to review them before
James.
Opening the hearing for House Bill 404, an act relative to support contempt hearings. The chair recognizes Representative Testerman to present his bill. The chair recognizes Vice Chairman Pat Long to present the bill.
Thank you, Mr. Chairman. For relative to support contempt hearings.
Thank you, sir. Chair recognizes Dana Albrecht, who asks for a minute. You do not say in your pink card whether you're for it or against it.
Turn your mic on.
Thank you.
Forgive me. Dana Albrecht, I believe the intent of this bill, like the one we just heard, or one of the intents, is to ensure that things that need to happen in family court proceedings happen in a timely fashion. And I think that that intent is an extremely laudable goal, and I think that's something that the committee should try to do. Right now, we have 100% of DVs that are handled in an ex parte fashion, no notice to the other party, while other stuff can languish on the docket. So I just encourage the committee to vote at a minimum to retain something as a vehicle just to make sure we get things done in family court in a timely fashion. And that's all I have on this, unless there's questions.
Any questions? Seeing none, thank you. Chair recognizes Vivian Gerard. And she says 3/4. I'm going to say that's 3 to 4 minutes, not 45 seconds.
3 or 4 minutes, correct.
Got it.
Thank you, Chair and members of the committee. So this one actually has a very strong, I guess, it leaves a strong effect here, because if you're allowing people to do non-payment for child support filed by the other parent, what happens when you have a parent that intentionally short pays the child support arrears every month? So for instance, if I brought my ex in there because child support hasn't been taken out the full amount and he just kind of pays what he wants when he feels like it, I don't understand how that really can play into effect. And as far as being able to go schedule like a mediation, these arrears should not be up for debate. What they owe, they owe. And I noticed in the past, because of my own case, a lot of these arrears, once they go up for appeals, they actually disappear. Again, something else that I don't understand. So if somebody has all these scapegoats all the way around to get away from paying their child support, especially when somebody makes $150,000 a year and he's taking extravagant vacations and buying extravagant property, I mean, this actually does cause a very big strain on children. So having your numbers for arrears be mediated, it just doesn't seem like that makes sense. I mean, that's going to be violating some kind of federal law here for the child support. I was looking at the RSA 461A14 that you're referencing here, but it seems like that is already written into the law. So why should it get mediated if somebody willfully does not want to pay their child support payments? And why is people not being held accountable? So if you have working class people that are making a true effort to pay their child support, why are they being held to the highest standard when you have a white collar person like my ex that he has no ramifications for not paying his support? So here we are now looking at former Judge Intocaso. She owes the state $78,000 in her settlement. Nobody's holding her accountable for her debts. That is still a state debt. So why are all these arrears just getting forgiven and just kind of getting pushed off the books? My ex is the only person I've ever met that the arrears go away. And this is a true problem. Here we are struggling to support the family, and somebody just can walk over and mediate their arrears. From what I understand, arrears should never go away. I do have some handouts that I'd like to give to you guys, because I strongly believe that numbers speak 1,000 words. And where you're looking at two different income class people and looking at the arrears and their form of payments, I think that this will really give you an eye opener of what the Child Support Bureau does. And one of the concerns, somewhat unrelated to this bill, is the fact that why are they not collecting based on the court orders? Why are they collecting what they feel like and not following the court orders? And why are all those arrears not being calculated properly? So I do want to pass this out, and I would like to find out how multiple people are not being treated equally.
Thank you for your testimony, both oral and written. And are there any questions? Representative DeSimone.
Thank you, Mr. Chairman, and thank you for taking my question. Are you for or against this bill?
I am against the bill.
Thank you, ma'am.
If you could hand that to Representative Bickford, your stash of handouts, please. Any further questions? Seeing none, we'll await her written testimony.
Two copies?
There's two different items.
There's two different ones.
Yep, I think so. Yes, yeah. Chair recognizes Mr. Randall Collier. Who signs in also in opposition to the bill.
Thank you, Chair and Committee. I'm Randall Collier. Thank you for the opportunity to oppose this bill today. I oppose this bill in direct contradiction to Troxville versus Granville, 530 U.S. 57, year 2000, in case where the Supreme Court of the United States, citing constitutional right of parental rights to the direct upbringing of the children, struck down a Washington state law that allowed any third party to petition the state courts for visitation rights and parental objections. Unless obviously in a court of law, illegal search and seizure for child support has to have due process. And speaking to the lady behind me, just to help her about the payments of child support. The way I understand reading all the federal rules, that if you cash a check for payment, then that's a payment. It may not be in full, but that is a payment for child support. And if it's cash, then it's a legal tender. I don't know her case, but I just wanted to speak on that. So anyway, I just wanted to oppose the bill for child support and arrears, as Supreme Court ruled down that without proper due process, the court has no interest in child care. Any questions?
Any questions for Mr. Collier? Seeing none, thank you for your testimony. Chair recognizes Attorney Richard Head from the Judicial Branch to speak to the bill.
Thank you, Mr. Chairman, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. Truthfully, I don't understand this bill at all. The bill does two things. It inserts a new paragraph Roman 1 in 461A14 and repeals RSA 461A14 paragraph 18. And I know, Mr. Chairman, you have a copy of the statute in front of you. If you look at paragraph 18, which is the same section, so 461A14, paragraph 18, which would be, I'm sorry, Roman 18, yes. So the last paragraph in
It's
that,
the last paragraph.
in that
Thank you,
section. At least I went through it word for word, and it's the exact same as the section that's being added to paragraph 1. So as near as I can tell, the bill repeals 18 and inserts it instead as paragraph Roman 1. And I don't know why, and I'm not sure what the goal was in doing that. Whether or not paragraph 18 needs amendment or changes, that's a policy issue. But as near as I can tell, the bill goes word for word and just inserts a new paragraph 1. It creates complications. I'm not sure if paragraph 18 is cited anywhere, but if it is, any citation to paragraph 18 now has to be paragraph 1. So I honestly don't know what the intent of doing that was. Just for reference, moving something from 18 to 1 doesn't give it any more priority. They're all important. So we just don't understand it. And with that, I would conclude my comments. I'd be happy to answer any questions.
I will agree with you, Counselor, that what I read Roman 18 to be is the wording of the paragraph that is inserted. And to my reading, I see the bill changes absolutely nothing.
I couldn't find anything myself either. So if it does,
I've got it here.
I also have it, and I looked
Yeah.
at it and I can't find it. So if there is a change, it's subtle. But I couldn't find it. So it may create, I just don't know if we have a form that cites to this paragraph, if, what we have.
And it moves 1 to be 1A.
It creates a new 1, which is paragraph 18, and then shifts everything down, or shifts 1 into 1A, so you don't have to renumber everything else.
With the indulgence of the committee, I'm doing a side-by-side at much slower speed than I did initially to make sure that there is absolutely no
And
change.
I've done it 5 times very slowly, and because every time I do it, I think I'm missing something.
You keep this up, I will go to law school. That was a compliment, by the way. They look dead on, word for word, the same.
Punctuation appears the same, everything appears the same.
Thank you. Any questions for Attorney Head? Thank you, sir.
Thank you.
I see no more cards. Are there any more cards that want to come up on 404? Close the hearing on House Bill 404 and open the exec session on the same House Bill 404. Again, we find that the prime sponsor is absent. There is no co-sponsor. There is no one present to testify in favor of the bill. The testimony is as you heard it. Paragraph 1 of the existing law is simply renumbered paragraph 1A. The new paragraph 1 is word for word identical to 461A14 Roman 18, which is repealed. I agree with learned counsel that this bill changes absolutely nothing. Any further comments, anybody? Chair will entertain a motion.
Thank you, Mr. Chairman. I'll move ITL on House Bill 404.
The chairman owes Representative De Simone a second. Would you like to second?
Certainly.
Second, Representative De Simone. Any further discussion on House Bill 404? Seeing no further discussion, I call the question on House Bill 404. The motion is inexpedient to legislate, moved by Representative Long, seconded by Representative De Simone. Would the clerk please call the roll? If you wish to ITL the bill, it is an aye or yes. If you don't like ITL, it is a no or a nay.
Chairman Pearson,
Aye.
Representative Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball,
Yes.
Representative Panic is absent. Representative Seidel,
Yes.
Representative Grossman is absent. Representative Levesque,
Yes.
Representative Petrino will be voting yes. Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Moulton,
Yes.
Representative Raymond.
Yes.
The ITL passes 14-0 with 2 not in attendance.
Any objection to this going on consent? Seeing, hearing none, the paper for the committee report will be given to Representative Long, who will get it back to me before the close of business today. This ends the executive session on House Bill 404. Before we go off to a long lunch, a couple of business items for the committee. I've been asked to read House Committee Temporary Replacement Policy. We will be having next week a morning of execing some bills. I'll send you all an email ahead of the calendar. So if you are not going to be here, or you're going to want to spend time elsewhere, listen to this. Any House member unable to participate in a scheduled policy committee meeting may be replaced on a temporary basis using the following protocol. How to notify of your absence. Contact your chair or designee of the chair or your ranking member, Democrats, to let that person know you cannot participate in an upcoming executive session, and do that as soon as possible. Your chair or ranking member will then determine if a replacement is necessary. Not all meetings necessitate a replacement. If we plan on not execing, if it looks like the bills are controversial enough that we will not exec immediately, you don't have to worry. But if we are going to exec, or it looks like we're going to exec, and that's not always easy to determine, you'll want to contact us. If it has been determined that a placement is necessary, this person will notify your respective caucus office, either the House Republican office or House Democratic office, so that the staff there may begin the process of identifying a member to replace you for the day on your committee. The caucus office then submits a written request to the Speaker's office, who approves the request and notifies the proper entities to make sure that the replacement is on file with offices who manage the meetings and keep the records. Deadline. With House committees requiring an in-person attendance by legislators, staff must be given the appropriate time to identify a replacement, which may be one of many vacancies they're trying to fill on any given day. Therefore, all requests for temporary replacements must be received by the House Republican or Democratic offices no later than 4 p.m. on the day prior to the meeting. And by the way, if you have to notify myself or Vice Chairman Long, you got to do it before then, because then we've got to make the call by 4 p.m. As a committee member, it is extremely important to notify your chair or ranking member as soon as possible. Don't wait for the deadline, because your caucus office will still need to identify a replacement, contact the Speaker's office, and notify the proper entities, which takes time. When can I be replaced? Most replacements happen when executive sessions are expected or properly noticed in the House calendar to ensure each party's vote counts are not affected by absences. Keep an eye out for executive session notices in the calendar, and I will try to let you know ahead of that time. And stay in contact with your chair or ranking member to determine if votes may be taken on any given meeting day. You cannot be replaced due to conflicts with other business in the State House or the LOB. If you're in the building, you cannot be replaced, no matter what else you're doing. For example, you cannot be replaced in your committee in order to introduce a bill in another committee, or attend another hearing, or in the House or Senate. However, you can be replaced if you serve on two committees that happen to have conflicting executive sessions scheduled. Can you be replaced for a partial day? No. If you seek to be replaced, you're replaced for the day. How long is the replacement good for? Members are typically replaced one day at a time. However, if you expect to be in an extended absence, you're having surgery, you'll be out for a couple weeks, your caucus office can indicate the period of an extended absence or replacement if necessary. Can I request to replace myself with someone of my own choosing? No. Only the Republican or Democratic leader can request that a member be temporarily replaced. Please work with your caucus office to determine the best way to handle your replacement. Any questions on replacement policy? Representative Seidel, I knew that before you did that.
On the 24-hour or 4 p.m. the day before, if it's the holiday on Monday, where we meet Tuesday morning, would it have to be the Friday previous, or is it still that Monday?
I don't know.
That's a good question.
You want their home phone numbers? Actually, that did come up once, and I did call one of the members of, in my case, the Republican office on his cell phone. And I don't know what he said after he hung up, but he was very polite while he was on the phone with me. So I don't know. Yeah, do you see that coming up? Okay, it's in general, a hypothetical. Okay, that's a good thing to ask. Any other questions? Sure.
Thank you, Mr. Chairman. I want to apologize for being late. However, every Tuesday, there's a chair and vice chair meeting. And Mr. Chairman and I have decided that we're going to take turns. He stayed last one, I stayed this one. So, and Representative DeSimone would also be late because she's a vice chair on another committee. So, just to let you know that on Tuesdays from 9:15 to 9:45, I believe. So one of us will be late, and that's the reason why.
We call him the designated survivor, okay? Yes, Representative DeSimone.
Thank you. I just want the people in the audience to understand that we mean absolutely no disrespect. We understand that the bills will be called when they're called, and if we come in late, we mean no disrespect at all. Your testimony is very important to all of us.
Let me give you a up to the minute heads up on House Bill 120. It has been noticed in the calendar for executive session at 3 o'clock this afternoon, and I cannot exec it any earlier. What we have planned, this is lots of people, bipartisan, bicameral, even by branches of government, is that Senate Bill 1 on the Sununu Center replacement has passed the whole Senate unanimously, has come over here, it has bypassed this committee, and is going directly to House Finance. They will deal with it, I believe, tomorrow, and it will go to the floor of the House as soon as possible. I've been asked to entertain a motion to retain, which means we hold on to it. 120 this afternoon. So any of you who are here, I do need a quorum, so don't all leave. We will retain the bill, which may mean if we really need it for some reason, if something goes wrong in the process, we'll have it in our pocket to deal with. If everything goes right and is signed into law, the hope is by the end of February at the latest, then we will just simply take this up at a later date and agree to kill it. So that's the plan. This takes place from 3 o'clock 00 to 3 o'clock 30 seconds this afternoon. All right, with that, we will break for lunch and come back at 1:15. You get a nice long lunch this time. For Bill 411 that we're going to be hearing in a few minutes, please make sure they come down. Keep those cards and letters coming. I just have one, which could mean I've lost several others. Yours? Yep. Okay, good. Fine. Who he? Well, I should. Nope, this is for 6:35. Yeah, he's good. Thank you. That's all right.
Did you find your bag?
Didn't look. I had a meeting over the lunch hour. Open the hearing on House Bill 411. The chair calls Representative Testerman, the sponsor of the bill. Seeing that Representative Testerman is absent, Vice Chairman Long.
Thank you, Mr. Chairman. Mr. Chairman, I'd like to introduce House Bill 411-FN relative to the mediation of cases involving children.
Thank you, Representative. You have the bill before you. It is very, very small. It repeals RSA 461 A7, and instead we read, the court may recommend mediation and give parents referrals of certified mediators, but the court shall not order mediation. That's what this bill seeks to do, simply is to take away ordered mediation. Chair recognizes Attorney Richard Head from the Judicial Branch to speak about the bill.
Thank you, Mr. Chairman. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. With this bill, I do sort of understand, I think, the idea that is behind it. The bill itself is very short. The section, though, it seeks to repeal and replace is actually fairly long and detailed and sort of talks about mediation in under 461A. I did want to talk about our mediation program, why it gets issued as an order, and what some of the consequences would be of not allowing these to be issued by an order. First, just in terms of the concept of mediation, whether it's ordered or whether it is simply created by the parties themselves, not through an order, the mediation itself is a process that does not require the parties to reach agreement. It is an opportunity to reach agreement, and it's an opportunity to reach agreement on some or all of the issues that may be coming before the court in their particular case. The court and the judges and the staff, we do strongly encourage parties to mediate. We have, as you've heard me say, and you'll continue to hear me say, an extremely busy system. And the more the parties are able to reach agreement, the more issues they can resolve on their own, the fewer that are in before a judge. And when you're in front of a judge, it is going to be adversarial. It is the nature of the proceeding. So the goal is, wherever possible and whenever possible, to have the parties reach agreement. And if they are unable to do so on their own, they do it with the help of a mediator. So why is it that we order mediation, which in and of itself is not a process that requires the parties to reach agreement? It seems a little almost contradictory in the sense of, well, when you get there, you don't have to actually reach agreement, but you're being ordered to go there. And there are some very practical reasons associated with that at some level. One is payment. So if the parties are free to go out and select their own mediator and pay their whatever it is they're going to charge, the mediator can charge whatever they want to charge, and the court is not going to help fund that. If an order is issued under this statutory provision, the rule kicks in regarding how much the mediator is going to be paid, and the mediator is going to be paid for $300 for up to 4 sessions, plus an hour of 4 1-hour sessions, plus 1 hour of administration time. That is just sort of baked into the fee. So unlike some who might charge $300 an hour, $300 for a half day, whatever it may be, the fee is set by rule if it's issued as an order. If the parties are indigent and unable to pay, again, if it's issued as an order, the court's arbitration and mediation fund will pay for that. But it still has to be issued as an order. We're not going to pay the private mediator $300 an hour. We're going to pay the mediator, it's on the list under the court schedule, the $300 for 4 hours plus 1 hour of administration time. So there is sort of a practical reason we do an order. Sometimes the parties will come to the court and say, we want to mediate. Great, I'm going to issue an order to mediate, because then they get into the system, they get into that process that without the order, they're simply not going to be eligible for it. So there is sort of a very practical reason why we do this as an order. In terms of the mediation process itself, we do sort of evaluate whether or not it's working, how it's working, what the feedback is, and the participants in a mediation are asked to complete a survey. It's completely voluntary. If they choose to, great. If they choose not to, then that's their decision. So we have like survey results from 2021. I think it's 2021. I might be wrong about that. We had 127 people participate in the survey, and it was a pretty even split in terms of how they resolved. About half of them settled all the issues, about 22% settled some of the issues, and about 23% settled no issues. So you get a mix within the people of who's providing feedback. So the question in the survey, did the mediator explain the process clearly? 98% said yes. I was treated fairly and with respect. 98% said yes. The mediator was impartial and treated all parties equally. 95% said yes. Mediator helped us explore options. 91% said yes. And then probably the most important, I would use mediation again if needed in this or any other case. 91% said yes. It is at least the feedback we receive is very positive, very favorably. Obviously, you know, it's a positive. They get positive feedback. It is a beneficial process because it does resolve issues. It brings people together in front of a professional mediator who then is able to help people identify the issues, see if there's areas of agreement, see if there are areas where simply you cannot agree, and narrow potentially or eliminate the issues that are going to be brought before a judge in a adversarial proceeding with witnesses, with testimony, whatever it may be. So the bill simply eliminates all of that and says parties use the free market, decide whether or not you're going to be mediating, and you lose an awful lot by doing that. So we do not support the bill as written because we really do need to have all of the tools available to us to be able to try to resolve issues and bring parties to agreement as opposed to the adversarial process that you see in a courtroom. With that, I would conclude my comments. I'd be happy to answer any questions.
Attorney Head, would you guess along with me that perhaps the reason for this bill is that there may be circumstances where it would be a bad idea to order mediation? And with that in mind, are you familiar with 461A7 Roman 5, which reads, "The court shall not order mediation if there's a finding of domestic violence." That is to say, the existing law takes into account reasons why this shouldn't happen. So a blanket statement is overreach?
So thank you for the question. I think the answer is yes. And it is extremely important and difficult because there's some that we know there's been a DV petition filed. Then you get into some that are more difficult. the judge may not have affirmatively heard from a party that's an issue. There's a goal to make sure that if there's to give everyone the opportunity to do that, and it's also through the mediation process, and have the mediator and the mediators are knowledgeable about whether or not parties should be in mediation, or if there's an undisclosed domestic violence issue or some other issue that, if brought together, creates a greater risk and creates more problems. Whether that aspect of it can be done better or worse, this bill simply does not address that and creates more problems because it takes the court out of the equation entirely.
Any further questions? Representative DeSimone.
Thank you, Mr. Chairman. And thank you for taking my question. I'm not really sure where this bill is headed, but when I read RSA 461A7, and if I go to Roman 4, it gives a list of reasons the court may choose not to order mediation that include but are not limited to. And I can't imagine inserting anything else than this in this laundry list of undue hardship, an agreement between the parties, which would mean there's no need for mediation, allegations of abuse, alcoholism, drug abuse, psychological or emotional abuse, available suitable mediators. So wouldn't this cover the gamut, in your opinion?
So thank you for the question. I think so. If we thought there should be other reasons, one, there's nothing stopping us from saying it's not on the list, but for whatever reason, these parties in front of us should not be together in a room in a mediation. The list is not limited to. So absolutely. So to answer your question, no, I'm unaware of any other specific circumstances where it would be helpful to include in the list, and the list is sufficiently broad to allow us to go outside of it. If there are instances where parties have been ordered into mediation where they shouldn't have been, we need to hear about those instances and as to what happened and why, so that we can learn from them. But that doesn't mean that we should, as a blanket rule, eliminate the court from being involved in ordering mediation. I think that's just a different step that is really not even just an overreach, but is ultimately harmful to the process.
Representative Bickford.
Thank you, Mr. Chairman. What I didn't notice in here, the statute, is anything about those that may have agreed upon all their points. Some people do. They say, well, we just want to part company and we've already made our agreement how we're going to split up things. Do they need to go through the mediation?
They don't. So we do. So thank you for the question. There are a significant percentage of cases, by significant, truth, I'll say 20 some odd percent, and I might be completely wrong about that. So don't hold me to it.
Don't write it down. Okay.
Don't write that one down. But it's a substantial number who are going through this process, are able to reach full agreements and file agreements, and they have almost no court interaction.
Well, if I may follow through, but I don't see it in the statute that it says that they would be excused from mediation, and that was my point, I guess. Do we need anything like that?
So,
Or should we? Should I say?
I'm not going to find it under. They
I
don't.
don't-
They
I'm-
do not.
I've only got 7 in front of me. I don't know if there's something before
Yep.
that or not.
If the parties have reached agreement, so the other aspect of this is, so at the first session, there's somebody in the court system that's assigned to their case, and we'll meet with them. And if they're reaching agreement on their own without the need for a mediator, they are not going to be forced into a mediation where they've already resolved all the problems. Sometimes the parties are able to reach agreement, they just don't know how to sort of document it. So they go, okay, we'll either work with the court staff person and sort of then document it, or maybe they need to use the mediator to sort of finalize the individual terms. But no, parties are able to and do reach agreement without going through a court-ordered mediation.
Okay, thank you.
Representative DeSimone, I think you had a point of information.
I did find a point of information to your question, Representative Bickford. It does discuss, the court shall not order mediation if there is a finding of domestic violence as defined in 173B:1, unless all parties agreed to mediation.
But that's under that, if I may, that's under the domestic violence part. I was speaking broadly about not people necessarily coming under that umbrella.
Thank you.
Yeah, thank you.
In going to the Representative DeSimone's point in the list, it's not limited to this list. So if the parties come to the judge and say,
Yeah.
we've got everything reached, we're done. We're not gonna force them into a process that they don't need. And in that circumstance, we do though, if there are issues, we do pretty strongly encourage people into mediation.
Thank you.
Further questions, anyone?
Representative Simone, what was the number? 173?
Seven.
Thank you, Counselor.
Thank you.
With the concurrence, I almost said complicity, concurrence of the ranking member, I close the hearing on this bill, 411, and open the exec session on the same. Any discussion? Once again, the sponsor is not here, nor is there any co-sponsor who could answer any questions. There has been no positive testimony on this. And as we heard, section RSA 461A7 opened up, we understood that there are reasons where the court would not order this, and I think we understand that a domestic violence situation is well within that boundary. We also saw that there's numbers of reasons why the court might choose not to. We also know that if both parties are indigent, I'm quoting the law, then the mediator shall be paid a set free. It seems that to my mind, possible reason why we should, in a blanket way, strike the court's duty to get mediation going on have been answered in the law already. And that there's nothing to be gained by this bill, and there's quite a bit that could be lost. That's just my 2 cents worth. Anyone else? Chair will entertain a motion from Representative. Are you making a motion?
I'm not making a motion. I wanted to make a comment.
I'll just entertain your comment.
Excellent. Thank you, Mr. Chairman. I have concerns that we would be tying the court's hands with this bill. as opposed to, it seems like the court has adequate discretion at this point with the current law. So I'm essentially echoing what you were saying before, but I just wanted to let you know I'm in agreement.
Thank you. You can be my echo anytime. Anyone else? Now, the chair will entertain a motion. Representative Levesque.
I move ITL.
Representative Levesque moves ITL.
I can second that.
I heard you wonderfully. Thank you, Representative Perez. And I wish to say to the committee that I attempted to tease the good representative this morning in a way that was not the best way to do it. And I apologized to her, and I wish to apologize to the committee. The fact is, I don't hear well in any language. My ears are not good. So thank you, Representative, for your graciousness. And your second. Any further discussion? The motion before us is on House Bill 411 FN. The motion is inexpedient to legislate, moved by Representative Levesque and seconded by Representative Perez. And the Assistant Clerk, please call the roll.
Chairman Pearson,
Yes.
Vice Chairman Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball, yes. Representative Panet is not in today. Representative Seidel,
Yes.
Representative Grossman, not here, sorry. Representative Levesque,
Yes.
Representative Patrigno is not in. Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Moulton,
Yes.
Representative Raymond.
Yes.
So that's going to be, it should be 13-0. The ITL would pass.
13-0. Any
Yes.
objection to consent? And Representative Levesque, before close of business today, if you could write out the,
Mr. Chairman, has there been any written testimony come in on these bills? No? Okay. Because I know my email got messed up and I was wondering if I was missing something.
I didn't see any.
Thank you.
This closes the exec session on House Bill 411 FN. We will resume at 2 o'clock for House Bill 635, I think. Is that right? Oh, good. Which will repeal parenting plans and the contents of parenting plans. So you got 20 minutes.
Chairman?
Mhm. Chairman Bob, I know that we share this room with you. Have we overstayed our welcome and you've got your people coming in? Thank you. Well, we'll clean up the damage and you'll have it in good shape for tomorrow. Okay. other. I hate to break it up, but it's 2:00. And we will now hear House Bill 635, the part of testament is played by law. Okay. And the chair calls Representative Testerman to present his bill. He is the prime and sole sponsor of House Bill 635. And the chair recognizes Representative Long.
Thank you, Mr. Chairman. I'd like to introduce House Bill 635 FN relative to court-ordered counseling and parenting plans.
Thank you very much. Any of you who either have hard copy book or have it online, this is RSA 461A4, which is all about parenting plans and the content of parenting plans and so on. And I see the bill is to eliminate all of this. The chair recognizes Mr. Randall Collier to come up and speak about the bill.
Thank you, Chair and committee members, for allowing me to speak about this bill. I agree that it should be the whole point of parenting plans and children's best interest. Once again, the Supreme Court has ruled that Troxel versus Gavel in 2000 that the courts don't have any interest in family as equity is property and finances and not actual people.
I'm sorry, clarify that. I'm trying to get my mind around. You're saying that the court, would that be the U.S. Supreme Court?
The family court.
The family court
Yeah.
of New Hampshire?
Correct. Or any family court. It's not a criminal court, right?
Okay, right.
So the
Okay.
Supreme Court, the U.S. Supreme Court has ruled that the family courts don't have any ground or interest in the family issues because for the child's best interest, it's not to have a third party arbiter speaking on behalf of the kid, especially when the judge doesn't know either party.
Would you give the Supreme Court citation? You did a minute ago, and it went a little,
Yeah.
I don't hear well.
Supreme Court, Troxel versus Granville, 530 U.S. 57 in year 2000, where the Supreme Court said that family courts studies.
I'm sorry, that was still too fast. I didn't get it. I got
Could you
Troxel.
spell the names of
So
the
the case is Troxel versus Granville, Troxel
Troxel
versus Granville, Granville. And the case number is 530 U.S. 57 in the year 2000.
Thank you, sir.
Okay.
Stating that it's a constitutional right for parents to direct the upbringing and not have a third party arbiter. Furthermore, with parenting plans in regards to court ordered counseling, I hate to use this as my case because it's an ongoing thing. The judge or the family court doesn't have, with the evidence submitted, such as like psychological records and psychiatric records, my judge decided to contradict both medical records and then give me counseling for 25 different hypothetical orders. The very first reason the judge gave me for supervised visits, and this was 12 years ago, was so my son doesn't lose memory of his good relationship with his father. That was the number one reason I got supervised visits through the family court in New Hampshire. Not only that, the judge said that I was confused, which is kind of weird because he's practicing medicine without a medical license, and I didn't really understand that. So anyway, yeah, I agree that it should be appealed or repealed. And there is no best interest of the kid when there's Title 40 incentives through the federal government to give the judge matching funds every time he grants child support. So there's no actual incentive for the judge to actually follow due process. So, and I have all the evidence. Any questions?
Representative Nelson.
I'm just a little confused because I pulled up the statute and it's talking about parenting plans, like in terms of holidays and birthdays and schedules and transportation and exchange of the child. So I'm confused about how your testimony is pertaining to that.
Well, when the judge grants the parenting plan, right, it's supposed to be in the best interest of the child, and it's not supposed to be a party granted equally, not all for one parent, right? That's actually not what happens in New Hampshire if you want to see the evidence. So there is no best interest from a judge granting for a child that he doesn't know, right? If he gets matching funds through the government to run his courtroom, he's not looking out for the best interest of the kid. He's running a business. So the parenting plan should be mediated between both parties only and not anybody else. The Supreme Court's already ruled on that. So, but it says an act relative to court-ordered counseling in parenting plans. So if the judge contradicts the psych evals and then practices medicine with a medical license, that needs to be addressed first before we try and change any rules.
Thank you.
Any other questions?
Chairman. Down here.
Representative Bickford.
Thank you, Mr. Chairman. Well, I think society has been using the system of a judge since King Solomon. Now, Troxel, I don't know if you're aware, was a grandparent rights issue, and not between two parents. Well, there was two parents involved, but one died. And the case came out of Washington. It's what gave us our why we didn't give grandparents similar rights as parents. So I don't think that's really the right case to cite for this.
Okay.
Thank you.
Any further questions? Representative Moulton.
Thank you, Mr. Chairman. So in all of the evidence that you presented, I was a little confused on if you support this bill as written or not.
I support repealing the parenting plan bill.
Okay.
In the because there's between the 461A6, A7, and I believe A2, there's a lot of discrepancies that need to be addressed that go along with the parenting plan that I found very conflicting information. That's why I submitted it to other parties.
Follow up?
Follow up.
I guess I'm not sure that why you would suggest that repealing parenting plans in general would be the solution to there being issues with just one parenting plan.
There has to be an equally agreed upon parenting plan, right? So the judge just can't order a parenting plan without actual due process and having your rights actually taken away by a proper court. So until that happens, which it never does because they always give protective orders in family court without actual proper criminal prosecution. So when they do that and they implement a parenting plan, it's always in the best interest of usually the mother. If you go by statistically, it's like over 90%. I don't have the exact number. And we have to figure out why that is and why the family court is making these rules for parents when they're directly contradicting the evidence that's submitted. So that's we have to get to the bottom of it before we fix other things. So if you're just fixing small things, you still have a bigger problem that they're still not following law and doing what they're doing. Like a judge can't say that you're confused if your eval says you're not, right? So when they implement plans that are actually directly contradicting the evidence, we have to have a bigger discussion of what's really going on in these family courts.
So then are you suggesting that if there was no legal parenting plan that the court followed, that they would just implement what you and your ex decided? Is that what they would have to implement something, right?
Well,
So
First of all, they have to have legal jurisdiction, right? So if you're not wanted for a crime, they can't make orders over you. They can't just arbitrarily say, "Well, your son has your last name, but you're not going to get to see him for 12 years," right? Which happened in my case. So they have to be able to run the program legally. First of all, they have to have jurisdiction over you. So if the parents can't communicate, there has to be a way to communicate for a plan, right? And that's why we're here. It's just not in the best interest of the child to have a judge do it, right? Because he's getting financial funds to run his courtroom. So when they do that, it's a conflict of interest. So they're never going to look out for the best interest of the kid when they're doing a parenting plan. So in mine, they said, Mr. Collier will know exactly what's expected of him, right? Well, why is anything expected of me if there's no evidence of wrongdoing? Should be 50-50. So we have to fix the problem ahead of the small statutes. And statutes are really only followed and agreed upon. If they're agreed upon by both parties, then they're legal. But it's not an actual ultimate law, supreme law of the land, it's Constitution. So a lot of these statutes are unconstitutional. So before we start writing these, we need to figure out why they're unconstitutional and why they're being written the way they are.
You have a follow-up? Anybody else? All right, thank you so much.
Thank you.
And the chair recognizes Matthew Hayes, Attorney Matthew Hayes. BCSS, Bureau of Children. Anybody? What? I should have known that. Thank you. I got the HHS part. I took 6 years to learn that one.
My apologies, Mr. Chairman. I'll write it out next time just to make sure.
Probably for about 6 months, and then I think I'll be good. Okay?
No problem.
Thank you.
Thank you. My name is Attorney Matthew Hayes from the Bureau of Child. Oh, I turned it on this time.
Okay, now we're even.
Now this time I need to make sure I get it towards my where I'm talking. Very quickly, I just want to thank you for letting me to speak on behalf of the Bureau of Child Support. Sort of a housekeeping matter is how I would refer to it in court. It was requested that the Bureau provide a fiscal note, and most recently when we reviewed the docket on the House's website, it said that it was still outstanding. We submitted a fiscal note I believe January 13th. I know that the LBA is working hard. I'm sure they're super busy, but I just want to make sure that the committee, if they didn't already have it, wanted to know our fiscal position was that this bill, as a policy decision, we're neutral, but there's no fiscal impact that we were able to determine for our program. So I just want to make sure the committee had that information.
No fiscal impact. Thank you.
Happy to take questions, but I generally, on this type of bill, we don't deal with parenting plans, so I really didn't add anything other than really no fiscal impact. I just didn't want it to look like that we didn't respond.
Representative Moulton.
Thank you, Mr. Chairman. I know he said you weren't going to take any questions, but I thought that the child support section is under the parenting plan, is it not? Or is that a separate section?
No, I'm sorry if I misspoke. I'm happy to take questions from the
okay.
committee always.
That's what I heard.
I just, my program deals with enforcing and establishing child support orders. Where resources are confined towards that end, and we don't deal with parenting plans, so
When it's written in the divorce papers, doesn't the child support fall under the parenting plan?
the child support would be issued in the uniform support order, which is a separate form, a court form.
I see, okay.
And I'd be happy to provide a blank copy to the representative if you wish.
No, it's okay. I just wasn't sure if this bill would repeal that. So, okay, that's all.
Child support's not in here.
But if it was part of the parenting plan, then it would end up incidentally repealed in the event it was in the parenting plan. If it's a separate issue, then it's not going to be.
Yeah, it's,
That's why
Okay,
I was just
that-
asking a question, if it was or
That's-
not.
Well, I think child support plans are somewhere else in here. But to eliminate something that isn't there wouldn't preclude it coming in later under another heading?
I got the answer because it's not under the parenting plan, so it
Okay.
would not be repealed.
I'm
so.
glad we had this conversation. Anybody else? Thank you so much, Counselor.
Thank you for your
And
time.
we now call on Attorney Richard Head from the Judicial Branch.
Good afternoon, Mr. Chairman, members of the committee. My name is Richard Head. I am the Government Affairs Coordinator for the Judicial Branch. We do not support this bill, which would repeal the section dealing with parenting plans. I don't know if you remember, but when Judge Gardner came and spoke at the introductory session, he identified our parenting plans as one of the most effective tools that we have in parenting cases. After that presentation, I did forward a copy of our parenting plan form to the committee. I'm happy if anyone wants another copy to resend it. It is a well laid out form that follows the statutory provisions, and it provides a step-by-step basis for parties to go through and identify really all of the parenting issues in fairly simple ways, but in great detail, parenting issues that the parties need to resolve and try to resolve before coming before a judge. And the goal of the parenting plan is for the parties to reach agreement on the content of that parenting plan, not to have a parenting plan imposed upon them. And it takes the parties through the essential elements of what needs to be in a parenting plan. Who has decision-making responsibility? What are the residential responsibilities and schedules? Holiday and birthday planning, 3-day weekends, vacation schedules, supervised parenting time if applicable, other parental responsibilities, and just lays it out in fairly simple terms, but requires the parties to think about it and hopefully come to resolution. Or if they can't come to resolution on all of them, they come to resolution on a large number of them. So a couple things with regard to the bill, which would eliminate the statutory provision on parenting plans. By the way, there are a lot of references to that section throughout the statutes that are now left hanging if this were to be repealed. It's unclear from our perspective, as to why it is that this bill would come forward, where one of the essential things that has to be resolved in a parenting case is parenting issues. And if we take away that essential tool, sort of how do we come to those resolutions? And I appreciate the thought of, judges. Why are judges making these decisions? Judges are not making these decisions if they don't need to. If there is no agreement, or if the agreement is ultimately not in the best interest of the children, the judge gets involved. But the judges are not looking to get involved. They're looking for the parties to reach agreement, looking for something that works, and that is most likely going to happen when the parties develop it themselves. So in summary, we do not support the bill. We find the parenting plan process is extremely effective and is an essential tool for the courts to have, and taking that away will have significant ramifications in these types of cases. And with that, I would conclude my comments, but I would be happy to answer any questions.
Representative Moulton.
Thank you, Mr. Chairman. What would you anticipate would be the outcome in the event that there was no parenting plan whatsoever?
So thank you for the question. I suspect we would implement something through a rule. And we would have to, because I'm not quite sure what else we would do. It is the thing that we're trying to resolve.
You would like a follow-up, wouldn't you?
I sure would.
You may have one.
Thank you. How would you, so, I mean, I foresee a lot of issues with this. So,
I see more than a lot of issues.
so like how would you hold someone in contempt? Like, how would you know that you've met all of the different, that you've fully resolved how, like, to parent between these two individuals that are,
As a practical matter, I have to assume without knowing that as a branch, we would need to develop essentially a parallel process through rulemaking. And through a court rule and through a court. I mean, we have a form, we would probably just implement the form through rules, but I don't get it. I don't get why the statute would come out, and it creates just sort of logistical problems within the statutory framework of everything we have as a form that references the section needs the work that would go into change, fixing the statutory and rule and form references for what we do not understand to be the reason is a lot of work that would take a great deal of resources and then to create essentially a new process is just at a time when the court does not have sufficient resources. It is unclear as to why we would be doing that.
Anyone else? Representative Raymond.
Thank you, Mr. Chairman, and thank you, Attorney Head, for taking my question. My question is kind of a more global question than just New Hampshire. So we have this great parenting plan form, which is, frankly, in my opinion, a model for other states. But pretty much every state has their own, and there's a federal law, the Uniform Custody. Uniform Child Custody.
I'm trying to help you,
Jurisdiction
but I'm not going
and
to. I'll fail
Enforcement Act.
miserably. So.
Oh, but Chairman Pearson knows it. The Uniform
I can read.
Child
Uniform
Custody-
Child Custody Jurisdiction and Enforcement Act.
Yes. So I guess my question is, would we run afoul of those federal requirements? Should we get rid of our parenting plan?
It's a good question that off the cuff, I'm going to be reluctant to answer.
It would be easier if I said it right the first.
No,
times.
that's fine. I get what you're saying, and I knew what you were saying. I just wouldn't have been able to come up with the words. I'm just reluctant to answer that since I didn't specifically in preparation for today sort of think that through.
Okay.
So I apologize.
No, that's all right. Thank you.
My question is, if all this went away, there's no requirement for a parenting plan to be worked out by the parents. And if all this went away, wouldn't it be the case then that we have no mandated procedures if one parent relocates and takes the child or children? That we have no mandated holiday, birthday, vacation planning, that we have no mandated legal residence for a child for attending school, were all this to go away. So my question is, would this not mean what happens in these and other issues is by which parent is the stronger and can get away with it? If there is no mandated having them work a plan out?
I think what it would, so thank you for the question. I think that, yes, I think at some level, every single time there is any disagreement, which is true anyway, but if we don't have a parenting plan in order to fall back on, they're just continuously making it up without an underlying order document template to say this is what we're falling back on. This is the default, which is the parenting plan. You want to deviate from the parenting plan, come back to the court and tell us why and tell us how why that is. But at the end of the day, the parenting plan will be the thing that resolves disputes. and the goal is to try to limit ongoing future disputes and to have this outlined through the plan.
So is it the case that absent a parenting plan, it would either be the tougher, stronger, richer parent would rule it because of force, or there would be constant going back to the court, constant documents, constant expense?
I think
Every
the
time.
latter. I think the latter one, and at some level, to the extent relative to the first, if there is a disparity financially, that party can use that in a way to the detriment of the other for the pure sake of doing it to the detriment of the other.
Thank you. Any further questions, Representative Vice Chairman Long?
Thank you, Mr. Chairman. So, Mr. Head, the part of this chapter they're looking to repeal also states that neither parent shall be described as having child reside primary or primary residential responsibility or custody or primary residential parent. So in your opinion, would we revert back to judges giving a parent the primary care parent or the primary residential period, which gave us all these issues that brought us to this?
So thank you for the question. I think probably, at least in the short term, we would sort of stick with what we're used to, but I don't know how it would start to change over time, and where it flows back into. And you know, you lose the structure and you might start to lose the structure within the decision making. That's why I do think ultimately, if this were to pass, there would be another structure that we would just have to create separately, because that structure is sort of essential.
Okay, thank you.
Representative DeSimone.
Thank you, Mr. Chairman, and thank you, Attorney Head, for taking my question. Isn't it true that wherever there is an area that could be in conflict in this parenting plan that I just read, it gives the opportunity to the parents to resolve any issue, and if they cannot, that is where the court intervenes?
So thank you. Yes, that is absolutely right. And that is absolutely what we want. And so that is the goal.
Thank you.
Anyone else? Seeing no one, thank you so much.
Thank you.
Any pink card on House Bill 635 that has not found its way up here? Seeing none, I will close the hearing on House Bill 635. We want to go to exec, and I now open the executive session on House Bill 635. And let's have any discussion we might want to have before we entertain a motion. Representative Raymond.
Thank you, Mr. Chairman. I think the theme today has been a general feeling of concern on the part of some of these bills about how long the process is taking in family court, you know, and allowing families to proceed potentially more efficiently through the system. And I think that's a laudable goal. I think that the court could use something to assist it with that. I just don't think that these bills, on this one in particular, is the mechanism by which we fix or improve the system that we have. I said earlier, I think that the New Hampshire parenting plan form is a model. Having worked in New York, and I'm familiar with Massachusetts custody, it's much better than those two other states. I can't speak for all states, but ours is so much more user-friendly and easy to understand. So my opinion on this one is that, unfortunately, once again, I don't think it should move forward as written.
Thank you so much. Anyone else? Representative Moulton.
Thank you, Mr. Chairman. I have a lot of concerns about this bill. I think it's unsafe if we take away a parenting plan. We have nothing to put it in place. The parenting plan is designed for protecting the kids. I think the only way to, you're right that we have problems with bottlenecking in the courts, but the only way through that is to get more judges. We need, deregulating isn't going to solve it. It's going to cause more problems in the long run, which is going to make more people have to go back to court for different issues because they didn't have it in writing to begin with. And we're creating more problems than we would be solving.
Thank you. Anyone else? Representative Log.
Thank you, Mr. Chairman. I mean, I think I know the intent of this. I mean, after listening to Mr. Collier, I empathize with him. I get it. Why was it so long for him to get to visit his child? That I don't understand, and I get frustrated over that. I see where this would just get rid of that. However, it'd be just like when I eat a cupcake with my diabetes, it goes skyrocket. So I'm going to put in a bill to get rid of cupcakes. It affects me, and to get to the detail of the problem would be better. I'd be more open to that to see if we could get a fix than just throw something blanket like this across where it's going to create other issues. So yeah, I'll be in opposition.
I would put in a bill to eliminate diabetes, but that's just me. Representative Bickford.
Thank you, Mr. Chairman. This is important to me because it was 20 years ago that I filed this for parenting plans. It hadn't been heard of before in New Hampshire. Something I picked up and saw in the state of Washington and brought it forward. When I presented it, I was pretty much laughed out of the building, and nobody was in favor of it at that time. So, but there was an attorney in the audience that heard me speak to it. And his name was John Cameron. He had come into family law, left chemical engineering to do that after his divorce, and we created another bill. I believe it was an amendment that created the Family Law Task Force, which I highly recommend doing again. And we looked at all facets, and we rewrote the family law statutes. And we took children out of the marriage part, put it into its own place, because not everybody that's married has children. And so we came back in 2005 and we got it passed. And I see there's been that section that you, Representative Long, spoke to, is very important to fathers in particular, because the old system was visitation, and people viewed that as losing their parental rights. They weren't a parent; they were a visitor to the children, and we felt that the language needed to change, because we didn't have parental rights and responsibilities. It was custody, or ownership, and visitors, and this is one of the biggest things we did. So I'd be privileged to do the ITL.
You anticipated my request. All we need is a motion.
Well,
Are we
if
ready
ever-
for a motion or any more sharing, discussing? Representative Bickford for a motion, please.
Thank you, Mr. Chairman. I'd like to move ITL on
House Bill
House Bill
635.
635. Thank you.
And Representative Gregg would like to second it. Yeah, you may second it. And you may turn your microphone on and second it as well.
I'll second it again
You- you-
with the
you're,
microphone this time.
Your microphone is on, and you'd like to second this, wouldn't you? I thought so. Okay, good. Any further discussion before we have the roll called? Seeing, hearing none. Thank you. The motion before us is ITL on House Bill 635 FN, moved by Representative Bickford, enthusiastically seconded by Representative Gregg. Thank you. Yeah. And when the clerk's ready, please call the roll.
Chairman Pearson,
Yes.
Vice Chairman Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball, yes. Representative Panic is not here. Representative Seidel,
Yes.
Representative Grossman is not here. Representative Levesque,
Yes.
Representative Patrigno is not here. Representative Perez,
Yes.
Representative Gray,
Yes.
Greg, I'm sorry. Representative Moulton,
Yes.
Representative Raymond.
Yes.
That would be 14 yes, 0 no's, and 3 not here.
No, it's 13. There's only
Sorry,
13
I
people.
wrote 13 and I
Did you vote
said
twice?
14. I don't know why. I wrote 13, I said 14. Don't ask me. And
I
0
get to
nays and
ask,
3.
but thanks for
sorry.
reminding me. No, I appreciate that.
My
Any
error.
objection to consent? Seeing, hearing none, it's on consent. And if you know where the papers are for Representative Bickford to fill out the committee report, they're in the stash here somewhere. And also, have we given you one for your? We didn't. It's not personal. We just forgot. Okay. And... Okay. 1, 2. And this closes the exec session on House Bill 635. And I hope you'll all stay around, have some fun with chatting with each other, because I have to wait till 3 o'clock for a 30-second exec session on House Bill 120. So, thank you.
Mr. Chairman,
What?
may I caucus with the Republicans on the committee in the office next door for about 1 minute or 2?
You may, all Republicans. That would be you, Representative Nelson.
Mr. Chairman, would it be okay if I put my ear to the door?
You can do that. Representative Long, you can even join us
Of the committee for a minute, please. Just want to let you know what we're going to be doing on February 7th, a week from today. We'll be having an executive session at 9:30 in the morning. And if you've got a pen and pencil ready, paper ready, or your phone, I'll give you the numbers of the bills we will be execing. Next Tuesday, 9:30 a.m., exec session 218. Rules and transcripts in family court, Representative Bernardi. 108, confidentiality of reports, Representative Spillane. And I've since gotten from our esteemed committee researcher a very nice document to that effect. 126, accrual date, that is accrual, not a cruel date. For child support payments, also Representative Spillane. 124, temporary alimony, Representative DeSimone. 547, rebuttable presumptions of sole custody determinations, Representative Testerman. And then for hearings, I put down at 11 o'clock. Did we exec it? We did? Where was I? That's worse. It'd be better if I wasn't.
I think you were frozen.
I was frozen. Okay. All right.
Yeah.
Thank you. All right. That'll go on consent. I agree. Hearings, 11 o'clock. HB 491, the prohibiting of restraints. Representative, is it Muse? Pronounced M-E-U-S-E? Muse? Okay. And then 115, notice you're getting a little longer lunch hour. Reunification therapy, Representative Nutter Upham. 306 is what I have. Then 2 o'clock, HB 49, modifying the definition of neglect, Representative Corcoran. And 245, HB 551, DCYF, tracking and publishing of stats, Representative Corcoran. So that's on the agenda. I open the executive session on House Bill 120, and the chair will entertain a motion to retain. Representative Long.
Thank you, Mr. Chairman. I'll move to retain House Bill 120.
Is there a second?
Right here. I'll second that.
Representative DeSimone. And as we've explained before, SB 1 is the platform that's going to drive this, and HB 120 is in reserve in case we need it. There being no further discussion, the chair will call the roll on House Bill 120 FNA. The motion, Representative Long, motion to retain, seconded Representative DeSimone. And you know how they often say no celebrations in the gallery? Well, in this case, I'll entertain the people in the gallery doing the wave. Go. Clerk may call the roll.
Chairman Pearson,
Yes.
Representative Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball, Representative Panic is absent, Representative Seidel,
Yes.
Representative Grossman is absent, Representative Levesque,
Yes.
Representative Petrino will be voting yes, Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Moulton,
Yes.
Representative Raymond.
Yes.
Retain passes 14-0 with 2 absent.
Thank you. Excessive celebrations are now welcome. This closes the exec session on House Bill 120. Thank you, everybody. Have a good rest of the week.
All right, we don't have Raymond's,
Wasn't it worth coming over?